Mr. Huma, first of all, if the legislation, you promote states making the decisions and pursuing their path in their state. What we were designed to talk about today was name, image, and likeness. I would take from your testimony that if we were successful, or the NCAA was successful in developing a program that rewarded compensated athletes for NIL, that would be insufficient, and that would then lend itself toward the next step of additional compensation or other ways of compensating what are today amateur athletes?
No, my only concern with federal law is that it rolls back what the states are doing. And really, though, there are about 28 states in play. The legislation looks very similar. It's independent representation, and it's freedom on name, image, and likeness. And there's not, while there could be some additional guardrails in terms of recruiting incentives for transfer, there's not any artificial caps. It looks like what America looks like. It looks like, similar to the other leagues. If you're a free agent, you go somewhere, you're on a team, you're free without restrictions to get endorsements in whatever area that team happens to be in. But the concern is this, if the federal government acts and acquiesces and grants the NCAA an antitrust exemption, which is, it's already abused without an exemption, there's an extreme trust gap. We've seen what the NCAA has done as if it had an antitrust exemption. So those are the issues, but it could be positive. If there was a good bill, it could be definitely positive.
Well, let me ask the question in a different way. If NIL became the rule of the land, however that comes about, Congress, the NCAA, and amateur athletes were compensated for their name, image, and likeness, then would there be other steps that the athletes would take for additional compensation? And while you said the states are generally have similar kinds of legislation that are pending, New York and ticket revenue would be an outlier. And my question is intended to get to, would this be sufficient to satisfy the problems you see for college athletes today if NIL was addressed and addressed appropriately?
That basically is economic justice from our perspective we've been advocating for. I think a lot of it would be in the details because, as we've said, this is a multi-billion-dollar industry. So if we're talking about crumbs, then absolutely not. If players truly got real economic justice that reflected their value, that might be a whole nother conversation. It would be hard to say without any details.
I'm not trying to prejudge anything, but I can always, in many of the things I get involved in, the argument against something is don't do it. It's the camel's nose in the tent. And I was trying to figure out if there's something more on the horizon that then is required beyond NIL. And I take it your testimony is NIL, if done appropriately, provides economic justice that you're looking at for the players.
It does. I again, without the details, because I think we have different opinions about what that justice would look like, but potentially.
Thank you, Mr. Spencer.
Yes, thank you, Chairman Moran. That idea assumes that every single athlete is going to have the brand to capitalize off of NIL. What we end up looking at is the truth that NIL, while it might be a solution, it's a solution to a different problem. Quite frankly, when it comes to the compensation, if we're looking at that as the broader issue here, we have to really evaluate how much compensation a student athlete is actually going to be able to receive if we go to that type of model. Individuals earlier mentioned the New York situation. That 15% then would probably roll out of either the university or other different parties, and that means that money's not going into those athletic facilities. And for me, as a student athlete, I want that. I really appreciate having upgrades to my facilities. They've got a new toy at Georgetown University when I go lift that measures your bar speed. And for track and field student athletes, to be able to know how fast I'm moving the weight is incredibly beneficial. So these are the kind of things that we're looking at, but as we move forward, we have to really examine whether or not NIL is the appropriate model to give student athletes the adequate compensation that is discussed.
Well, Mr. Spencer, you lead me into my second question, which is my concern is, you're in front of a committee that has lots of members from rural states with small schools. You from New Mexico have an understanding of those schools. I want to make certain we take care of athletes who who aren't necessarily in the sports that generate significant revenues or profits at universities. And I think Mr. Huma, I mean, as we've had this conversation, he's come back to many of my concerns to tell the committee that those disparities already exist. So when I began the hearing, toward the top of my priority is how do you take care of places that the schools are small, the programs don't generate a lot of revenue, there are sports within those schools that are not money makers. You want to take care of women and the issues of Title IX. And the question to me is, does NIL solve, does it create more problems in that regard? Does it create greater disparities between the top schools and the top athletes in the top programs in the top sports? Is there a greater disparity that occurs because of NIL, or does all those problems, that disparity that I'm worried about that comes from compensation, already exist, and this is not a relevant topic to that disparity?
Chairman Moran, if I may, you hit the nail right on the head. Even if some of these disparities exist, we don't create something that then exaggerates those issues. I think this is
the question is, this would then exaggerate those issues?
absolutely. Okay. This is also one of the reasons why this is such a complex discussion that involves all hands on deck, the student athletes, the senior women administrators. This is one of the reasons why it takes as long as it does, because in order to adequately answer the question of what success looks like, you need all of the stakeholders at the table having that discussion, and that's something that cannot be done overnight.
Mr. Huma has been strong in outlining his belief that the disparities exist today, and I don't have any reason to dispute that they do exist. Is there anyone, Dr. Girod or Dr. Emmert or Mr. Bowlsby, that would comment on NIL and those disparities? Are they exacerbated? Is the challenges made more difficult, or does this help address the issue?
Yes, Senator. Well, I will ask my colleagues to address it as well, since they're on campuses directly. Yes, indeed, it would exacerbate it, and that's part of the conversation about how can we create a model that has some form of guardrails that can mitigate some of those issues, but there's little doubt that it would, in fact, create greater disparities between schools and in some cases between the athletes themselves. That in and of itself may not be a reason not to pursue it, but it has to be done in a very thoughtful manner.
Mr. Bowlsby, you talked about Texas and Oklahoma, a couple of schools that we're well familiar with, and the difficulty they would have within the conference if Texas had different rules than Oklahoma in regard to NIL compensation. So what are do those advantages and disadvantages exist today? Texas, to me, is the place where the TV markets are within our conference. So are we solving a problem or adding to a problem with name, image, and likeness? Is recruitment more difficult one place than another already?
Thank you for the question, Senator. I believe recruitment will be made infinitely more contentious. There will be more disagreements among institutions as to who did what and who offered what, and was it the institution or was it an outside entity, was it a third party? Essentially, my thoughts on this are we need to modernize, and there isn't any doubt about it. We need to have continued broad-based programming that takes Title IX into account. We're not the NFL or the NBA. We don't have a draft, and we're not the Olympics. You don't have the prerogative to compete for anybody other than your own country. The liberalization and the modernization is something we should absolutely do, but it should not be per se pay for play, and it should not be a proxy for pay for play. And so with that caveat, as I said in my statement, between the idea and the reality, there's a shadow. How do you treat student athletes fairly? How do you put more money in their pocket? How do you allow them to use their name, image, and likeness without it entering into the choice of institutions or the choice of transfer. I would have hoped that Senator Thune was in the room for this comment, but one of the practical outcomes of this will be when you get to be a high-profile athlete at the University of South Dakota, you will be recruited away with inducements to play at a higher level. And if there's no penalty for transfer, it will be an open market of recruitment. And the concept of an unregulated recruitment environment and an unregulated transfer environment, I think, is an absolute certainty in this environment.
The issue of amateurs, in other words, that's not an employee-employer, employer-employee relationship, does NIL itself, with whatever we define as appropriate guardrails, does it change an athlete from being an amateur to an athlete being an employee of the university or the athletic department? Is there enough in NIL that legally changes the relationship between team and player?
Senator, if I might address that one, I think it depends. Should it be the case that the institution, that a university, was in fact orchestrating the NIL payment, if a university was in the midst of brokering those sponsorship arrangements, for example, I believe it would be extremely difficult to differentiate that from an employee-employer model. With sufficient guardrails to assure that this is being conducted by a truly independent third party, it's certainly possible that it might not. But that, again, is one of the details and challenges of working out this model.
The notes I've made today that NIL would have a consequence on recruitment, inducements is my note. What would occur in non-profitable areas of the country or in specific teams, the employer-employee relationship, not amateur, consequences to Title IX, somewhat related to the issue of profitability, but large schools and small schools, the consequence, the recruitment that you just outlined in regard to South Dakota. I don't know that that list is all-encompassing, and rather than take the time of the moment, I would ask any of you to lengthen that list or shorten that list for me as to what concerns we ought to have about NIL. I think I'm just about done. Let me ask Dr. Girod one question. You indicated, Dr. Girod, in your testimony about inextricably linked with the university model. And you highlighted some of the things that were involved in that and what athletics means to your university or to a university in a number of areas. I want to give you the chance to reiterate or highlight that component of why a amateur team or teams on campus is important to a university. We've talked about what this means to an athlete, the ability to get an education and a wider array of benefits. Why is having a sports team at a university important to the university community?
Thank you, Senator, for the opportunity to reiterate that and recognize that collegiate athletics is unique in the world. Does not exist anywhere else in the world. It is part of what makes our universities the envy of the world. It is part of what keeps, it attracts students, it attracts faculty, it keeps our alumni engaged, it keeps our donors engaged, and it creates a campus life that really cannot be replicated anywhere else. That benefits clearly our student athletes, and we've talked about how that is so today, but certainly it creates tremendous benefit for our students and the experience that they have while they're pursuing their education and equally growing into adults. But it is, you know, our athletics department does not fund the university. Fortunately, our university doesn't fund our athletics department either, so we are blessed in that regard. But the benefits that the university gains, again, being a Midwest university where we are relying on out-of-state student recruitment, being on a national stage on a regular basis, you cannot replace that.
Let me ask a question specifically related to the University of Kansas and how it would then have a broader consequence or an understanding. So we are a successful basketball program at the University of Kansas, historically and currently. And the concern has been the ability for schools to recruit athletes in other places. Even though the University of Kansas has such a successful basketball program, what's the consequence in regard to the ability for the University of Kansas to compete for athletes to come play basketball with NIL?
Well, I would not disagree with some of the comments that there are some disparities in the system today. Those do have somewhat to do with size of athletic budgets. They also have to do with history, and they have to do with success of student athletes that come through institutions. But the reality is today, we all play by the same rules. And that doesn't completely eliminate the disparities, but at least we're recruiting on the same rules. And we could just as easily lose a student athlete to any of the other conferences or to non-power conferences because we all play by the same rules, and it's about student choice and student fit. Potentially going into an unregulated environment, as Commissioner Bowlsby's mentioned, I think profoundly limits the ability of a school in a town of 100,000 people to compete in a media market.
Thank you. Mr. Huma, my last question is to you. Your testimony makes clear that you have concerns with the NCAA representing student athletes in NIL commercial agreements. You indicate that, I think this is a quote, not necessary for government to appoint a college group licensing entity. What type of entity is appropriate for that role?
So there are group licensing organizations. Actually, in the run-up to the California bill, when it was imminent that the bill would pass, I wanted to make sure that college athletes had a good vehicle for group licensing, like in some of the other leagues. So I reached out to the NFL Players Association. They have their own licensing company called Players Inc. Turns out they were in the middle of a kind of a big collaboration with Major League Baseball Players Association's licensing company because name, image, likeness globally is underutilized. So when I discussed these options with them, they said they would be happy to help. If these opportunities opened up for college athletes, group licensing is a powerful vehicle. Group licensing, you know, if you're familiar with the video games, for instance, it's one of those things where players receive an equal share of distributions, you know, regardless if they're the first string quarterback or the third string lineman. In college sports, it's very critical. In the O'Bannon case, as a matter of federal law, there was a group licensing market that was recognized, which includes video games, it includes TV broadcasts, it includes archival footage, advertisement, merchandise. And I think we agree, it sounds like we agree that the school should not be providing those kinds of representation. It is possible maybe there would be an employee-employer relationship established so they get involved, but in those instances, for instance, if there was merchandise and there's a jersey, it could be up to the apparel company to initiate some kind of a communication with the school and with the licensing company to say, hey, we wouldn't be able to do these things. We're willing to pay. The apparel company pays the licensing company so the players get their distribution, and it also pays separately the schools or whatever entity collaboration, whether it be other forms of group licensing opportunities. But the third party is the source of payment, and our concern with the NCAA is that there's a big conflict of interest that they've already been acted on, because by de facto, which was also in the rulings, it showed that the colleges, the conferences, and the NCAA are already selling players group licenses in all these different areas, giving the players absolutely no money. And so that's a big red flag when the NCAA mentions the opportunity to do group licensing as a matter of congressional federal law.